Hello, fellow seekers. I hope everyone is doing well. I hope you all have had a great week so far. I am continuing on in the Darrell Brooks case. And here we are. I have recorded a lot of different things. I'm putting them in the playlist. I am getting to the part now where they are preparing to do their closing arguments, because I have pretty much recorded a lot of the other stuff leading up to this. So there really isn't anything missing. I'm going to put it in the playlist, let you all know, and you can go check that out, any of those you might have missed. But we're at the point now where he is really, it's at the end. He's at the end of his rope here. And so he's going to be, I'm sure, volatile and doing everything he can to stall and be an idiot and annoying and all that good stuff. So, like I said, I have the videos. I'm going to put them in the playlist and try to label them so that you can find them the best way possible, because we've already gone through where he comes through and talks about his mom got something in the mail about a recall on the Rudd SUV. And, of course, he had ample time to question Ryan Schultz, the mechanical inspector for reconstruction. He had Attorney Basie said he had ample time to do that, and she was prepared, and I have all that there. He was mad about that, and then it was down to Mama Dawn being his last witness, and if he said she was going to be there, she's going to be there, and of course she wasn't there, and so he lost his right to that. And of course he's talking about his rights and you're putting me in, contempt, blah, 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 same old stuff. So now we've been through all of that stuff, and now we're to the point now where they're completing the jury instructions and they're preparing to do their closing statements. And let's just see what this idiot has to say. Okay, I don't think the mic's on for a few seconds or maybe a minute, but just look at him. He's staring at the ceiling for his Post-its, or perhaps an angel from God to help him out. But there's no help for this bozo. But I'm looking forward to getting this out, because these are things I don't believe I have filmed yet and shared with you all. And there's a whole lot to go through, let's face it, even with this and the jury deliberation and all the idiotic moves he tries to do for that. Look at him. He's just waiting for his moment to speak. Maybe not. We'll see. Oh, I've got a glare. Sorry about that. Let me fix that.
His yellow sheet. Yes. There's one on your, I got on your. All right, it's 2 o'clock. I'll call the case. State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good afternoon, Judge Sue Opper, Leslie Basie, and Zach Wichow, for the state.
Here without prejudice by special appearance. Beneficiary, I'm here under fraud, menace, duress, and extortion. Judiciary,
Lord.
This is a social security substitute trust action which you are a real party and interest to. As to jurors and propria persona. This is a military admiralty tribunal in maritime law. Title 4 of the United States Code, Section 1.
Oh, God. That's so funny.
Which you can see.
Sure.
Which states placing of fringe on a national flag is within discretion of President acting as Commander-in-Chief of the Army and Navy. Is this common law court, or admiralty court.
You shouldn't have time for all that, Darrell.
The records reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing a dress shirt. I know he has a suit coat, but it's not on. He's also wearing a mask. The court is not going to address any of the issues that he is raising, as they are meritless. I would also say the same as to the notes that he passed while he was in the other courtroom. For the record, I did provide a copy of all of those to the state as well. They are also uploaded into the file and are made part of the record. To the extent that he raises objections or lack of consent, it is noted for the record.
I was about to do that and say that I don't consent to being called that name.
We know. We heard you the first time. The first thousand times.
Trust name. It is not me, myself. I don't recognize that name, nor do I consent to being called by that name. With all respect, Your Honor. And we still have yet to address subject matter jurisdiction, what has yet to be proven on the record. May I receive those original copies time-stamped?
Shush. Idiot complaint
I need
forms.
to make a record of one part of a jury instruction that I do need to advise the jury. It will also be corrected in the packet. I believe within the last year, the jury instruction on credibility of witnesses was modified by the jury instruction committee, and it was just an oversight on the court's part to not include, it's really just one paragraph. It was read to the jury at the beginning of the case with the preliminary instructions, but it is a paragraph regarding implicit bias, and so I do think it's important to advise the jury of that. I intend to do that when they come out, and then again, the full instruction will be amended so that it's in the packet that goes to the jury. And Madam Clerk, if you haven't already, if you could print off page 72. It's the, it adds a paragraph before the last paragraph that starts with, "There is no magic way for you to evaluate the testimony." And again, I wanted to be consistent with the most recent version of the jury instructions and consistent with what was instructed or provided to the jurors at the beginning of the case. And so I will make sure that they have that, and so advise them when they come out. Also, I will read instruction 160, closing arguments. Madam Clerk, if you could just make the change so that it's of parties. We missed that correction as well. So it's the closing arguments of the parties, not the attorneys. And so I will just make that correction and make sure it's...
I accept for value in return for value this document. And Your Honor, I requested that I have copies of my filings from earlier, time-stamped.
Mr. Brooks, I'll provide you with the copies later on. I need to continue with the instructing of the jury and have the parties make their closing arguments.
Your Honor, with all respect, the state received copies. How come I can't receive the copies of my filings?
You know what? Well, I can give you the print-offs, but I can't give you the originals right now. That's what I'm referring to, and you will absolutely get those back. I guess I was mistaken that you wrote copy on it. I thought you retained a copy for your records. So with that, Madam Clerk will print off from the record. It won't be the yellow copies just yet. I'll take that up later outside the presence of the jury after the case has been given to them. Now, in terms of the closing arguments, I did set a time limit for the parties yesterday. Each side will have a total of 1 hour. Mr. Brooks, so that you are fully aware, the party with the burden of proof, which is the state of Wisconsin, goes first. Then you, as the opposing party, will have an opportunity to respond and argue. And then, time limit willing, the state also has the opportunity to present rebuttal because they have the burden of proof. And that is provided with the excerpt from the bench book that was provided to you yesterday. It has the purpose of the closing arguments is to summarize the facts. marshal arguments, focus the issues for the jury. I just talked about the order of the arguments. The scope of the arguments are the content, duration, and form of argument are within the court's discretion. That's why I set a time limit of 1 hour for the parties. And Mr. Brooks, I will advise you that I certainly will wait and see how you
he's so
present
put
your
out.
argument today. I will certainly wait to see if there are any objections raised, but I also want you to be aware that if I feel the arguments are improper, I may simply, without an objection, say, please move on, as a clear indication from this court that what you are stating is not proper under the various rules and case law that govern closing arguments.
Again, Your Honor, without prejudice, I'm here by special appearance. I don't consent to being called that name for the record.
It's noted, sir. All right, then with that, I will have the go ahead. Looks like Attorney Opper has some issues she wants to raise.
Yes, I just have one question, Your Honor. Would I have permission to put the easel up and display some of the poster boards? I did confer with Captain Dussault as far as security is concerned, and he agreed to it if the court would give me that authority.
Where would it be displayed?
He's gonna put it like right here, and then you want me standing at this table during.
I do.
Yes, so I would just position it like right here. And I don't have to leave it up through the whole thing. I realize it blocks the view of people in the courtroom. Detective Casey would be willing to assist me in removing them when I'm done with them, if that's okay with you.
I trust it won't block Mr. Brooks' view of the jury, and
That's
as long
what
as
I was gonna put it like right about here so that he could still see me and the jury.
with that caveat, yes, I will allow that.
All right.
Objection, what is that? What is supposed to be?
Oh,
Put it-
God. I don't have to tell you every damn thing.
They're previously admitted, Your Honor, it's Exhibit 15 and 130, I believe.
So are they exhibits? I'm confused to what they are.
Mr. Brooks, I made a ruling. The state has made a request. I've granted it.
Yeah, but I'm
In terms
saying
of-
I don't understand what's being shown. Should not have the right to ask, to object and ask what it is that's actually going to be shown.
The state's put on the record what it is. They are exhibits that have previously been received by the court during the course of this trial. That is proper for a party to do that during its closing arguments.
So can I put up exhibits?
Please.
Um,
You know what the hell you're doing.
Mr. Brooks, I don't know what you have planned for your closing argument.
I'm making a request, the same request. May I be able to put up?
It's not the same
It
thing.
depends on what it is, sir. So I'm not going to take up any more time because what I intend to do is, once the state goes through its closing, I may take just a short comfort break depending on how long it is. And if there's something in particular, you will need to tell me what it is. As long as it's an exhibit from this case, I wouldn't have an issue with it.
They would be from this case, obviously.
Yeah, obviously, yeah, sure.
It's not nothing that the state had.
I'm not aware of exhibits that the state wouldn't have, that you would have. Everything that's been received, we have a list. So if it's not something that was received during this trial as an exhibit by the court, unless you tell me what it is so that I can make a ruling, I can't see how it would be relevant or appropriate for your closing argument.
They're part of my filings.
It's damn filings
The
again.
filings have no relevance to the issues that are before the jury. The closing arguments are to direct the jury so that they have your arguments, so that when they go back to determine the issues in this case, which are related to whether you're guilty or not guilty of the 76 charges, things like subject matter jurisdiction or like that would not be something that would be proper before this jury. Those are legal issues that the court would decide. The jury is the judge of the facts. The court is the judge of the law. That's why I have all of these jury instructions to give to the jury.
I'm not referring to subject matter jurisdiction.
What are you referring to then? Be very specific so I can make a finding and move
I
on.
was specific.
No, you weren't.
My other filings that
That's
was
not
filed.
specific enough,
My-
sir. What are you
My
referring
court
to?
docket
Which
sheet.
filing?
Let me know when you're done, Your Honor.
Which filing, sir?
He's so
Not
rude.
generally, but specifically.
Are you done?
Boy, I'd love to smack him. So rude.
Are you done?
Sir, that's very rude and
No, I
disrespectful.
didn't know if you was finna say something.
I
That's why I'm
paused.
asking, are you done?
What filing
Your Honor,
are
how
you
come
referring
every
to?
time I try, even when I try to err on the side of caution, you find some way to make it to be something that it's not? I didn't know if you was gonna say something else.
Oh, it's something all right. You're just an arrogant idiot. And you have talked about your stupid filings that have nothing to do with your case, just like nothing else does. And say he's just getting more anxious and more like irritable about it because he knows it's, it's coming. And one thing I will say about Judge Darrell, I do notice that as it gets closer to the end, she really tightens up a lot more as far as just not tolerating a lot of his stuff. I mean, at least a lot better, I think, than before, because it's just like, okay, we're at the, we're almost to the finish line. Let's get this done, because all we all know, all he wants to do is stall and hold it up. And he's just, disgusting.
I've asked a question, sir, so when I do that, I would hope it would convey to you I'm looking for an answer. So which filing are you referring to?
All my filings, my notice of appearance, my statement of particulars, my bond,
Oh my God.
the court docket sheet,
No.
all of those filings.
The request to display those to the jury is denied. It's not relevant.
How's it not relevant? Not even your
That's my
oath of office?
determination, sir, so I am going to start this.
Not even your oath of office can be shown?
No, that is not relevant to these proceedings, sir.
It is.
It's not relevant in front of the jury.
Why is it not relevant? Can you
Mr. Brooks,
Get an attorney.
explain
you
why
are
that's
not
not
going to be
relevant?
Get an
able
attorney.
to raise those types of issues.
Too
and
late there
present a
now.
closing argument based upon my oath of office, whether I'm licensed to practice law in the state of Wisconsin,
I said your oath
whether
of
there's
office.
subject
I didn't
matter
say anything.
jurisdiction, whether you consent to this appearance or not. None of those things help the jury determine the issues in this case, which are related to whether you are guilty or not guilty of the 76 charges that have
The jury
filed
should
in
know
this
that
case.
they should know the truth in their duties, in their rights. They should know that at least.
And you wrote the book on that, didn't
I'm
you?
putting you on notice that if you continue with this insistence upon presenting information that's not properly before the jury as evidence in this case, that I will instruct you during your closing argument to move on and potentially ask the jury, have the jury leave so that I can admonish you. And if you keep insisting on that, sir, that will be in direct violation of the court's direction to
So
you.
they can't even know that I got a shock device on my ankles.
Again, another lie.
Absolutely do not need to know that.
Why
So it's
not?
not relevant to the determinations of guilt or innocence in this
It's the
case.
truth.
Mr. Brooks, your custodial status is not on trial here.
I will argue that it
Your
is.
conduct from
No, it's
November
not. You don't know.
21st of 2021 is
That
That
what is
hasn't
on
been
trial.
proven.
You may not bring up the way that you've been shackled. It's not relevant, sir.
It's
and if
the
you
truth.
do so, you do it at your peril. But here's the
There
thing:
is
the
no
jury
peril.
is specifically.
It's my right,
no,
though.
Let me go. Okay.
It's my constitutional right.
No, not really.
Just like
There are
under the
certain
First
things,
Amendment,
sir.
which I preserved my First Amendment right when I came in this morning, I also preserved my
Right.
Sixth
Mr. Brooks.
Amendment right.
Please stop. You do not have an unfettered First Amendment right. That is very clear based upon.
What do you
all
mean
the
by
case law.
unfettered? What do you mean by
Unde-
unfettered? I don't-
It is not
Unfettered.
absolute. It can be restricted.
So the Constitution of the United States can be constricted.
All right, Mr. Brooks.
You know,
I'm putting
he
you
didn't
on
know
notice
what the
that
hell he's
continue
talking
with
about.
Your insistence on raising issues that are.
I'm going to
really
raise
a
issues that the
distraction,
jury needs
that
to
are-
know.
They're not.
Regardless.
The jury does not want to know
they're
all that.
under the rights of the United States Constitution, which is the
Mr.
law of
Brooks,
the
I
land.
draw your attention to closing instruction 460,
I'm
which will be
going
read
to
jury
let
at
the
some
jury
point.
know the truth, their duty and their rights. Under the First Amendment and under the Sixth Amendment, I have the right to inform them of their rights, of the truth, and of their duties. Under the First Amendment and under the Sixth Amendment of the Constitution of these United States. You can't, no state law can override that.
Mr.
Any
Brooks,
law,
do you intend
any
to
law
keep this up when the
repugnant.
jury comes out?
Your Honor.
Because I need to
No, I
have
do
the
not.
state-
That's why I'm addressing this before
not-
they come out.
Now,
That's why I'm trying to address this before they come out.
There's nothing
so it
of
doesn't become an
importance.
issue once they're
Nah.
in here. But under the First Amendment and under the Sixth Amendment of the Constitution,
Gosh.
which are
Please
rights
send it
that
to
I
the other room.
preserved, the moment we stepped in here this morning when this proceedings started, I preserved those rights for the record. And now you're telling me that those rights are not, would you say unfettered or, I don't know what you say. I don't even know what that means. I don't even
yeah,
understand.
sure, okay.
But any law repugnant of the United States Constitution is null and void.
Mr. Brooks, I'm putting you on notice that you can also forfeit by your conduct the right to present a closing argument. In appropriate circumstances, the right to present a closing argument, no different than the right to testify, may be subject to forfeiture where your conduct is incompatible with the assertion of the right at issue. The goals that this court has attempted to follow throughout this proceeding are multifaceted and multifold. Number one, I do have an obligation and I have done my best to ensure that this is a fair trial. However, a fair trial does not mean a defendant has unfettered rights to state whatever he wants, when he wants. This court, not only through the course of the trial, is deemed with the responsibility to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process. It also includes ensuring that the closing arguments are relevant, are appropriate. This court must also be concerned with efficiency and effectiveness, and of course, last but not least, courtesy and decorum in this courtroom, what I would generally refer to as civility in the courtroom. You do not have unfettered First Amendment rights or an unfettered Sixth Amendment right, sir. You must conform your conduct to the rules of decorum, the rules of evidence, and the rules of procedure. While you have a right to present relevant and probative arguments to this jury, you may not present arguments related to such things as jury nullification, subject matter jurisdiction, the court's oath or lack thereof, if that's what you believe, whether this court is a court of common law, admiralty, all of those things relate to your claim as being a sovereign, which are frankly baseless. They're
And annoying
meritless.
as hell.
They've been debunked by many courts, including the court in the Beneby decision that's been referenced by this court previously. I will give you a fair opportunity to present a closing argument, but again, it is not unfettered. The simple fact is, sir, this court can restrict your right to present a closing argument. This court has the authority under 906.11, under the various cases, including Illinois versus Allen, including Rock versus Arkansas, although Rock versus Arkansas and Chambers versus Mississippi dealt with the right to testify. There is a decision, I looked it up earlier, I'll just pull it up and tell you the case site so that you have it. I would direct your attention to Herring versus New York, found at 422 U.S. 853, a 1975 case, although in a footnote, it does stand for the proposition that a defendant who has exercised the right to conduct his own defense has, of course, the same right to make a closing argument. That's quoting State Ferretta versus California, or following the same logic from Rock and Anthony in chambers, a right, even a constitutional right that a defendant has may be forfeited by conduct. This court, just like it attempted to do with regard to your right to testify and set up reasonable restrictions so as to meet all of the goals that the court needs to meet, will be as follows, and that is, again, sir, you may not bring up matters that are not relevant to the determination of guilt or innocence. That means evidence that was not presented and not received in this courtroom is not relevant to your closing arguments. It's not.
Look at his
the
face.
Arguments must be based on the law, not as you interpret the law, but as the law is.
He acts like he knows it all.
You must base your closing arguments on the facts that have been established during this case, meaning the evidence, the testimony. As I indicated earlier, the purpose of a closing argument is to summarize the facts, marshal arguments, and focus the issues for the jury. It is fair that you comment on evidence, including arguing.
He can't stand it because he wants to be the only one talking. He's the only one He's the only one that he himself is going to listen to, his own self-talk. He doesn't care what anyone else has to say because, of course, again, he's the smartest one in the courtroom, but we all know differently. That's what's irritating him.
Evidence to the conclusion or inference. It is your ability or your opportunity to convince the jury that you are not guilty of these offenses. You may not convey any idea that you have undisclosed information. Neither party may vouch for a witness or otherwise express personal belief or opinion regarding truth or falsity of any testimony or evidence. It would be improper to ask a jury to draw inferences that the parties know are not true. And your comments on evidence is limited to evidence in the case. You may not comment on facts outside the record or peculiarly within your own knowledge. And that is just some of the guidelines for determining the propriety of arguments that I am guided by from my judicial bench book and all of the cases that are referenced therein. So you are put on notice, sir, that even without an objection, this court may, in an effort to preserve the dignity, the decorum, and to keep the issues properly before the jury, may advise you during your closing argument to move on. If you do not honor the court's ruling, then you will run the risk of forfeiting your right to be present and potentially forfeiting your right to further present your closing argument. With that, I am bringing this jury out to complete the instructions that I need to complete, to add to the credibility instruction the paragraph on implicit bias, and to let them know the full instructions that they receive will have it, to read 160 closing arguments of the parties, and then to have the state go first as they bear the burden of proof.
Now, Your Honor, I'll just let you make your record. I didn't overtalk you. I didn't interrupt you.
It doesn't mean you have to talk.
Fair to say.
Why does he think he has to respond every time she makes her record? He just thinks that's how it's supposed to go. Look at him. Oh my God. Nobody wants to hear him.
I'll let you make the record. With all due respect, when will I be able to make the record? As I've tried to do numerous times by saying I wanted to present an offer of proof for my appeal. That's the chance for me to be able to make the record.
I'm denying your request to make an offer of proof regarding your appeal. I'm
not allowed to
required
make the
to
record
give you
at
that
all, Your Honor?
opportunity, sir.
I'm not allowed to make the record at all. As I just let you did, because some of the issues
You told me what you want to do. I told you you can't. I've addressed the request.
Some of the issues have been overtalking you and interrupting you. I did not do that.
But there's nothing for you more to say. It's done.
Everything that you said,
You have not proven for the record, and it's unlawful law. You haven't shown one time that is lawful for you to do what you've been doing as
Mr.
far as
Brooks,
your ruling.
Once again, I'm not going to debate with you the prior rulings of this court. There's absolutely no need at this point for you to make an offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
You will have an opportunity, if
I'm going to
convicted, to
inform the
raise
jury.
every issue you want on appeal.
I'm going to inform the jury of the truth, their duties, and their rights, as I have the right to do under the First Amendment and under the Sixth Amendment.
Oh boy.
You can't just disregard the United States Constitution. You can't do that. Again, any law repugnant of the United States Constitution is null and void. There's no state law that you can cite. There's no federal law that you can cite that overrides the United States Constitution.
Mr.
know
Brooks, I
this.
direct your attention to State versus Anthony. Although that case dealt with the right to testify,
Okay, so
its
we're not talking
reasoning
about
is
the right to
equally
testify.
applicable.
We're talking about the closing arguments, correct? We're not talking about testifying,
Oh,
which you
sure.
already made a
I'm not
ruling
going
on.
to delay.
Okay.
You
any
already
further
made
Please send him-
closing
send him-
arguments
But
of
Your
the
Honor,
parties.
with
okay.
all due
I will
respect,
address.
Okay, I changed my mind. She needs to stop it now. Move him. I know she probably had to tell him all that stuff for the record, though, so he wouldn't think his rights were being trampled on, like he said before.
Address your further request.
with all due
once the
respect,
state-
you already made a ruling about testifying. Did you or did you not?
Mr. Brooks.
So we're talking about closing arguments that I said it's my right to be able to inform the jury of the truth, their duties, and their rights. That is my constitutional right.
Mr. Brooks,
You
we are
can't
at the
tell
stage
me
of the
I can't-
proceedings where it is the state's burden of proof where they get to make their closing argument.
We're talking about me though.
Yeah,
understand
it's
that,
always
sir,
about
but
I'm going to
you.
inform
Your
them of the
conduct
truth.
right now is delaying
I'm not intending
the court's
to delay
intention
anything.
of moving
I
forward
let
Of course
with
you
the
are.
closing argument.
I just sat there and let you make the record. I didn't overtalk you or interrupt you. I let you say what you wanted to say.
Oh my God, that
I let you
doesn't
make the
mean
record.
that he has to respond to everything she says, though. He really does think that he gets the right to have his response, which no. Please move on.
I didn't interrupt you not one time.
No, but
So?
you're attempting to disrupt the proceedings by
I'm
going
not
off on a
attempting to
tangent
disrupt
into
anything.
all of
Yes,
these
you
other
are.
issues.
You know what she said.
From my
How am I-
perspective, that is in an
how am I
attempt
being
to
dishonored?
simply
How am I
delay
being in
what we're
dishonor?
doing.
How am I
So
being
you are
in
put on
dishonor?
notice. I am done dealing
How
with
am I
these
being in dishonor,
issues.
Your Honor? How am I being in dishonor of the court?
Mr. Brooks, I've made my determination.
And have I not preserved my
rights?
rights?
This further.
Have I not preserved my rights?
If you insist on interrupting the court and disrupting the flow of these proceedings by a blatant disregard for the parameters that I've set up, you will forfeit your right to be present in this courtroom and potentially forfeit your right to present a closing argument.
Under what lawful law can you do that?
Sir, I've
You
made
can
my
hold me in
determination.
contempt by
Oh my
Illinois
gosh.
versus Allen. You can do that. You stated that numerous times.
Mr. Brooks, I want you here for the closing arguments, but
Apparently
you
you
do
don't.
not want
Apparently
to
you
follow
don't,
the
Your Honor,
rules.
I
because
wouldn't
all
want him
I
there.
said was it is my right under the First Amendment and the Sixth Amendment to inform the jury of the truth, their rights, and their duties. I never once said anything about, oh, I'm going to bring up subject matter, or I'm going to bring
You're
up
right,
this,
sir,
or
and
I'm
I
going to
will
bring
wait
up
and
that.
see what you have to say, but I thought it prudent, given your conduct to date and your insistence on bringing up issues that have no bearing in this case.
This is a
They're
new
not
day, though, Your
relevant.
Honor. This
They're
is a
not-
whole new day.
That it was prudent on my part to give you some guidance before you potentially do that in front of the jury. But
Okay,
you're right,
but-
I will wait and see.
Your Honor, it's
But I
still,
need to get going.
it's still
and I'm going to,
unconstitutional for
sir.
you to
So
tell me that
you
I don't
need to
have
be
the First
quiet.
Amendment right that I preserve, or the Sixth
Mr.
Amendment
Brooks,
right
I'm
that I
going to have
preserve.
the jury brought out. I expect that you will be respectful, courteous, and quiet.
Or I'll be
And
held in
when this door
contempt.
opens,
Or I'll be held in
if you
contempt.
insist on making remarks, then I will excuse everyone from this courtroom and you will be removed because you will forfeit your right to be present for being disruptive.
Under what lawful law?
That
Because
is
I
my
haven't been
ruling.
dishonorable to the court.
Madam Clerk, please have the jury brought out.
Well, take me to the next courtroom then. Take me to the next courtroom, because you're not going to override my constitutional rights just because you feel like you can, and you don't have no lawful law to do that. We all have constitutional rights, and you cannot trample
Mr.
on
Brooks,
those.
what you are raising are essentially issues that you can raise on appeal.
No, I'm raising them now because they need to be on the record now. Because you won't allow me to make the record as I've let you do. You've even went so far as to mute
Mr.
me,
Brooks, the
which you
jury
can't
is
even,
coming
there's no
out.
lawful law to say that you
I'm
can even
advising
mute me.
you to be quiet. They're coming
Your Honor,
out.
does Illinois versus
Yeah,
Allen
but
say
he's
that
getting
you
more
can
loud.
utilize
He's
the
getting
mute button?
louder because
It
the
does
jury's
not.
coming.
Mr. Brooks,
So
when
you're-
that door opens, I expect you to be quiet.
You're,
and you will
you're,
forfeit
and I
your right
expect
to
for
be
you to,
present.
I expect for you to answer questions as a public servant, Your Honor. You're a public servant.
jury's coming
You're
in.
supposed to serve the people.
All right.
Take me to the next courtroom. Please, take me to the next courtroom. Hold me in contempt. Hold me in contempt. Hold me in contempt. Hold me in contempt. I have constitutional rights that are being trampled on.
Yeah, he's being trampled. Yeah, obviously he's doing all this for show. The jury, I would love to know what they're thinking. He just thinks that, I don't know what he thinks. He's just so idiotic. But he's going to put on a show for him, and that's probably why she's leaving him out, because, he can just go on and act the fool.
And you're coming up with ways to make a lawful law where it doesn't say in Illinois versus Allen anywhere about utilizing the
Records
mute button.
reflect that the jury bailiff is in here. However, the jury is still in the hallway. I'm going to give Mr. Brooks one more opportunity to be respectful.
Oh,
of the
no,
court's
don't do
rulings,
that.
Whether
No, no,
he
I
agrees
haven't-
with them
I
or
haven't.
not.
Yeah, just take him out.
I'm merely exercising my rights under the Constitution, under the First Amendment, and under the Sixth Amendment.
Mr. Brooks, your rights do not include you disrupting these proceedings
I'm not
the way that you have through
disrupting the
the course
proceedings.
of
You just
three
told
Oh,
me you
yes,
don't
he
have
is.
to honor my constitutional rights in so many words.
Oh, my
You use the
gosh.
mute button,
Mr.
that's
Brooks,
not
the
even in your
jury is
decision.
outside this door. They're not brought in
I'm
yet.
informed that
I'm
the jury. I'm
asking
informed
you
that the jury
to
is
be
outside the
respectful
door.
of their time.
They're not in the courtroom.
I'm
They're not
asking
present.
you to be respectful
Oh, my
of the
gosh.
court's ruling,
They're
whether
not
you
present.
agree with
These
it
are
or
issues
not.
that
Get him
need
out
to
of
be
there.
resolved
Get him out.
before
Get him
they're
out. Get him
present.
Mr.
out.
Brooks, they will not be resolved to your satisfaction.
It's not about my
The record
satisfaction. It's
has
about the
been made.
Constitution. It's about what's right.
Are you going to
Are you
follow
going to
the
answer
court's
questions as a public
requirement?
servant, or while you're making up laws that are not in the Illinois versus Allen? It never utilized the
the jury
mute button.
can
It
go
never
back
said
to the
anything
jury.
about a
Thank
mute
you.
button.
It is clear
Why
that
am I
Mr.
being
Brooks has
muted?
absolutely no intention of following the simple rules of decorum and courtesy. He has repeatedly talked over me. He's repeatedly interrupted. Even though I've made rulings, he's not respectful of the fact that I made a ruling, even though he disagrees with it.
How can you
I
make
attempted
it?
to bring the jury out,
How can you
and
utilize a mute
he
button?
continued to talk.
That's
So, Mr. Brooks, you
Your Honor,
have forfeited your right to
is
be
that-
present for the state's
is that
closing
not,
argument.
Your Honor?
You will
Can
be
you answer
taken
this
to the
question?
courtroom next
As a
door, and I
public
will
servant-
invite you back over when it's time for
You
your closing
can't
argument.
invite me back over. I can reclaim my right. So how can you invite me
All
to do
right, the
anything?
courtroom is to be cleared so that Mr. Brooks can be removed to the next courtroom, and I'll make appropriate findings when he's in the other
Yeah,
courtroom when I can
and
do
you'll
so
mute me, which you
without
can't lawfully do.
interruption.
You can't lawfully mute me. So now you're trampling over my First Amendment rights.
Look at this, would you all? Well, of course, he has been removed and now placed in the other courtroom. Thank God. But look at him, his face peering into the computer. It must be terrifying for the people on the other side to look and see his mug looking at them. But it's just like the things he was saying about his rights and why am I being muted? I mean, really, do they really have to answer that? What is it? You can't lawfully mute him. He says in Allen, Illinois versus Allen, you can put me in contempt or hold me in contempt, which of course he wants her to do, and she's not going to. But it doesn't say anything about muting me. You can gag me, you can do this, but they say there are at least 4 ways. And, he just acts like he knows everything. He knows nothing. And I'm so glad he's in the other room because it was making me a little bit crazy. So let's go on to the next phase of this craziness. Okay, let me see if I need to move this back a little bit. Oops. Okay. Maybe I need to move it up a little bit. The camera moves so often. It's hard for me to tell where to put this thing, so just bear with me. But maybe it would be good to cut off nothing. Oh, look at him. Can they... What is he doing? He can't stand being loved. Oh, good. Now he's going to start talking to everybody. You know, don't you... I can't imagine how sick they were of his foolishness. He knows that the cameras are on him, and he's going, look at me. Look at how sexy I am. You know, wearing an oversized suit when he probably could shop in the boys section. He just thinks the camera loves him. Apparently he loves it. I love it. A defiant child. Him and his not believing that he can forfeit his right and thinking that he's supposed to give his consent for everything. He really does think highly of himself, doesn't he? Why is he even asking them questions as if he doesn't know why he's in there? I mean, I don't know what he's asking them, but why didn't he just sit down and... Looks like he's watching a ping pong match. Is it lawful law? Judge Darrell trampled on his rights, please. Without even a thought about the rights of the victims and their families and just humanity in general. No ounce of respect for it, that's for sure. Okay, let's get on with this show. I'm just leaving it on, even though nobody's speaking yet, and it's no microphones are on. I'm just leaving it on in case he makes some sort of idiotic move, which could be likely.
So I need it quiet in the courtroom, please. We are back on the record. Appearances are as they were before, except that Mr. Brooks has been removed to the other courtroom. The court did that because we came out on the record at 2 o'clock following the lunch break. Mr. Brooks was brought to the main courtroom, and during that almost 35 minutes or so, he was insistent on raising a variety of legal issues with which this court has either previously addressed or which are meritless and do not warrant any further response.
Meritless.
He is insistent on making a record and an offer of proof. This would not be the appropriate procedural mechanism, meaning an offer of proof at this time. We are not in the midst of a trial where the court's made an evidentiary ruling that would require the preservation of the record by making an offer of proof. This court has been attempting, frankly, all day to get through the reading of jury instructions, to get to the point where the parties make their closing arguments, and ultimately to put this case in the jury's hands. It has been challenging. It has been met by resistance from Mr. Brooks. I would once again describe it as being stubbornly defiant, although at times he may wait for me to make my ruling. He continues to not respect the fact that a ruling has been made, and he wants to argue and re-argue and re-argue points that this court has already gone over. And in an effort to simply put him on notice regarding his behavior, given the history of this case, the court was attempting to set some parameters regarding closing arguments so that they are focused, so that they are proper, and that they follow the law. That was met with a considerable amount of resistance and repeated statements by Mr. Brooks that he has First Amendment rights, Sixth Amendment rights, 14th Amendment rights. He has all of those rights. That is not in dispute, but those rights do not come in a vacuum when we are in a court proceeding, in a trial such as this. The rules of evidence, the rules of procedure, the rules of courtesy and decorum all apply. And this case has demonstrated that a stubbornly defiant defendant can forfeit even important constitutional rights by conduct. That includes the right to be present. It included the right to present further witnesses and testimony, and it included the right of the defendant to testify on his own behalf. I hope that I do not have to go through a decision that forfeits his right, or that makes a finding that he's forfeited his right to make a closing argument. I will certainly wait and see how that goes. I would note he was very respectful when he did his opening statement. It was clear. He made a variety of points. He did so in a way that I would say was very conscientious of people's time. It was cogent. It was concise. It was probably about 35 minutes. I may be off a little bit, but that's what my memory is. It wasn't overly lengthy. I would hope that he follows some of those same things here when he does his closing argument. But he has been removed from this courtroom because of his stubborn defiance and disrespect of this court, of courtesy and decorum. And what I truly believe is an effort on his part to continue to delay and lengthen these proceedings. I've said it before, I'll state it again. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. And trial courts and trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. They noted 3 constitutionally permissible ways to handle such a stubbornly defiant defendant. But they also indicated that no one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. I've noted this before. This is a case from 1970. The technology that we now have in this brand new courtroom was not available then. I have the ability to have Mr. Brooks appear from the other courtroom by way of audio and visual means. We can see him, he can see us. I've confirmed prior to calling the case that the audio was working, that the video is working. The one camera, there's 4 cameras in my courtroom, there's 4 cameras in his courtroom. However, it is set to 1 camera since he's the only individual there, other than the bailiffs, but I'm talking about as a party to the litigation. So the courtroom, the cameras in my courtroom include one that would normally be on the witness stand that has been zoomed out so as to capture the large majority of the jury box. I even adjusted the camera that's on the state's table so that the exhibit that's currently up to my left, her right, Attorney Opper, is viewable in the camera angle, and she is still present within, meaning viewable within that as well. And although I've made a finding that he has forfeited his right to be present for the state's closing argument, I'll find that the technology that I have available, it is that his appearance from the other courtroom is the functional equivalent of appearing in this courtroom and being present due to the technology that is available. I do have him on mute for the time being because I needed to make a record, and there is a very lengthy history with Mr. Brooks during this case of him talking over me and my inability to make an adequate record if I am in a constant back and forth with him and trying to talk over him. And so I, yes, made the decision to utilize the mute function on the incoming audio. I know he disagrees with my ability to do that, but I believe it is consistent with
It's more like he just doesn't want to do it.
dignity, order, and decorum, that when appropriate, he be muted. I will advise Mr. Brooks once again that although he has lost his right to be present in this courtroom, he can reclaim the right to be present as soon as he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. That includes not interrupting the court. That includes respecting when the court renders a decision by way of an oral ruling, even if he disagrees with it. So with that, I will advise him that once the jury is brought out, I will unmute him.
Oh, no.
I expect that he will be respectful of them, and I expect that he will not interrupt as the court goes through the couple of final jury instructions I need to go through, including the reading of jury instruction 160, closing arguments of the parties. And then I will turn it over to the state, but I will unmute him at that point. So should he have an objection, he will be able to state objection. I will be able to rule on it. And again, I expect him to honor whatever the ruling that is made. And if he does not do that, then I will utilize the mute function. If he doesn't have it, we'll make sure he has the objection sign. And if I see that, I will unmute him to hear what it is and then make a ruling accordingly. Attorney Opper.
Two quick things. Please could you confirm that the audio and video are working in the next courtroom? And the clerk's shaking your head, they've done that. Thank you. I don't know if you want to do it now or at a later time, but I think we should make a record, as I will be displaying a PowerPoint during my closing argument, throughout my closing argument, and I'm not sure how that is projected in the next room or how it affects what we see in this room, Your Honor, but we should make a record of that at some point.
Thank you. My understanding is Madam Clerk has the ability, so that is displayed not only here, but in the neighboring courtroom. If you would be so kind as when you start displaying it, just make some type of record, excuse me, so that the bailiff who's over there, if it's not being properly viewable, if it's not viewable, that we can stop and adjust accordingly.
Okay. Thank you.
If you would like, before the jury comes out, we could do a test.
Yes, could we please?
Please. Madam Clerk, would you confirm with the clerk over there that the PowerPoint is also viewable? All right, and it should be similarly to what we see. So the monitors will display the camera that Mr. Brooks is appearing, that is on Mr. Brooks on the left-hand side of the TV, and then the 4 cameras for this courtroom are on the right-hand side, but it's probably maybe a quarter to a third of the screen, and then the remainder of the screen is the PowerPoint. The monitors in the courtroom that Mr. Brooks is in are no different than what they are here. He would have one at the table, but there would also be the very, very large TV monitor above the clerk over there. Well, it's smaller, and then the very large one over the witness stand. So it would be very similar to what is here if he were present in this courtroom. And again, I know that the diagram, it's probably not the most easily seen from a camera, but it's really no different than what I'm looking at the moment. So I appreciate you asking that I make a record of that. I would further make a record that there are headphones on the table where Mr. Brooks is currently standing. He has not put them on, but they are available should he want them. All right, then are you turning off the, all right, PowerPoint? Let us know when you need that function, and then Madam Clerk will be able to make that viewable in both courtrooms.
Very good, thank you.
All right, with that, the jury is to be brought out.
Okay.
Look at him. You know, he's gonna do some crazy thing like wave his hands like he's on an airport runway wanting to come back in.
All rise for the jury, please. Thank you, everyone. Please be seated.
Oh my gosh,
Ladies
look
and
at him.
gentlemen of the jury, when I read the jury instruction to you
Oh, here we
previously
go.
regarding credibility, I had a prior version of the
I'm glad
jury
they moved the camera
instruction.
off of
Now,
him.
what I read to you in the very beginning,
Oh,
at the
good
very
Lord.
beginning of this case, was the most recent. I am going to read a short paragraph, but also tell you that in the packet that will be sent with the jurors to the jury deliberation room, it will have the complete instruction, and it's instruction number 300, excuse me. And this is what I want you to know about credibility. In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. Consider carefully the closing arguments of the parties, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. With that, I will ask Attorney Opper to start with her closing argument. Go ahead.
And Clerk, if you'll please turn on the PowerPoint.
Oh, hold on one second. Mr. Brooks, do you have an objection?
Oh Lord.
Nothing.
I thought I was supposed to be unmuted.
You are now.
Oh my gosh. Just talk.
All right. Attorney Opper, you may start.
Thank you, Judge. Good afternoon, everybody. It's kind of nice to stand here in the middle of the courtroom. You know, all week or the last 3 weeks, they shoved me at the end of the table because I'm the lefty in the group. It's nice to be able to look at you all and say thank you. Truly thank you. Each and every one of you. I want to express our sincere gratitude from the prosecution team, myself, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Woodchild. There's no one in this courtroom that does not realize the sacrifice that you've made serving your community in this very important task. You've put your lives on hold. I don't even want to hear from your bosses. Thank you. You've watched these proceedings and you've noticed as we sit at our prosecution table, we don't have a client at our table. But rest assured, we do represent someone. We represent the people of the state of Wisconsin. It's an entity. I can't bring it to the courtroom. People enact laws. People want to feel safe. People have representatives in Madison or Washington, D.C. that set standards, rules that we all are expected to live by. And when those rules are violated, prosecutors step in and enforce the law. Darrell Brooks does not represent anybody. He does not have a client. Darrell Brooks is the client. Darrell Brooks, and it's consistent with any other criminal case you've ever heard about at any other time in any other jurisdiction. It runs the same, no matter what state or federal. I'm going to ask you for your guilty vote at the end of my comments. It's up to you. I can't tell you to do anything, except I'm going to say one thing to you that I wholeheartedly ask you to obey.
Attorney Opper, I'm sorry for the interruption. Your objection, sir?
Oh, Lord.
Mischaracterization of who I am and the way it was said. I feel like it was talking down.
All right, your
Please.
objection is noted. It's overruled. The state may continue.
You must not consider anything about Darrell Brooks other than his conduct in downtown Waukesha on the evening of November 21, 2021.
Oh, my gosh.
Nothing he's done before that.
What an idiot.
Nothing he's done since that. When you go back to that deliberation room, please obey Judge Darrell. Confine your comments to his conduct on November 21 of 21. Is he guilty of the 76 counts that he's been charged with? That and solely that should be your topic of discussion. So, what are the charges against Darrell Brooks? Thank you for your patience in listening to the jury instructions. They must be read for each and every count. But sadly, they can be summarized very quickly like this as far as the actual counts. Counts 1 through 6 are first-degree intentional homicide while armed with a dangerous weapon. Counts 7 through 67, first-degree recklessly endangering safety while armed with a dangerous weapon. Counts 68 through 74, hit and run causing death. Counts 75 and 76, bail jumping, and count 77, battery.
Whoa.
Mr. Brooks, what is your objection?
I have 76 charges, not 77.
Ooh, he's right. Damn, I hate when he's right.
It's mischaracterization of the charges.
That is correct. It is sustained. It should be count 68 through 73, I believe, and then 74 through 75, and then 76.
Thank you, Your Honor. I do apologize for my math skills.
You know, though, what's funny about it? Hey, she made a mistake. That's all right. Woo. The funny thing about it is that I thought he didn't identify as Darrell Brooks or know anyone by that name. But however, He said, I don't have 77 counts. I have 76. So he just admitted right there who he is. Not like none of us didn't already know, but that's pretty funny.
68 through 73, 74 and 75 are bail jumping, and 76 is battery. I apologize for that misstatement. We're going to talk about counts 1 through 67 in detail. Counts 68 through 73, hit and run causing death, in my opinion, are easily summarized as this. He never stopped. Never. Bail jumping, he was out on bail for 2 files in Milwaukee County, facing felony charges there. He was ordered to not commit any further crimes. If you believe he was involved in any of the conduct charged in counts 1 through 67, you should find him guilty of bail jumping. Battery, that relates to the split lip and black eye suffered by Erica Peterson.
Oops.
We told the
Nobody corrected her. She said Peterson. It's supposed to be Patterson. But that's good. That's okay. I mess up things all the time.
story kind of backwards. We started with the battery for background. First degree intentional homicide. You've seen this in our opening statement. You've heard it from Judge Darrell. Did Darrell Brooks cause the death of the victim, a victim? Did he act with intent to kill, meaning either the mental purpose to take the life of another or was aware that his conduct was practically certain to cause the death of another human being? Count 1, Ginny Sorensen. Count 2, Lee Owen. Count 3, Tamara Durand.
Oh, I got.
Count 4,
pipe down,
Jake
Darrell.
Willick. Count 5, Bill Hospital.
So rude.
Count 6, Jackson Sparks. Those are the individuals who lost their lives because of the conduct of Darrell Brooks. From there we go to reckless endangering safety. What is that? In this case, it means that through his reckless driving, he endangered the safety of other people. And he did so demonstrating utter disregard for human life. Now, behind me is State's Exhibit 15. It's also on the PowerPoint. If you choose, you may have this chart with you in the deliberation room to help you walk through each of these counts if you find it helpful. It's up to you. If you don't want it, you don't have to have it. But it will be available for you if you ask for it. And it'll take you, as we did in our presentation of the case, right down Main Street and address all the counts that were involved, all the counts that were charged. To prove reckless endangering safety, and I'm just going to go back one slide, nowhere do you see there that we have to prove any degree of injury to anyone. Never once did Judge Darrell instruct you that somebody has to be physically injured. Now, Detective Casey told you that was the standard we used in deciding of all these hundreds of thousands of people who included in these charges. And a decision was made by the prosecution team to include people who were physically injured to be efficient in our prosecution. And so everybody up and down the street, I would argue, had their safety endangered that day. I didn't charge 5,000 counts. We selected 61 counts of people that we can identify by name in Exhibit 15 that were injured by the conduct of Mr. Brooks. Those are the people in green. People in red are the fatalities. And we presented this case to you in much the same fashion that is presented here on Exhibit 15 as to how the injuries occurred going down that street. So we are absolutely held to our burden of proof and the elements for each offense that Judge Darrell instructed you on, but we are not required to prove any injury to anybody. The question is, was their safety endangered by his reckless conduct, his reckless driving? Now, some of the groups, pretty easy. They walked in a formation, and you can get a photograph or a diagram, and you can kind of see pretty easily who was located where, right? And you can think back to the videos that you've seen for each of these groups and remember, and you'll see them again, the path of the vehicle as it went through each of these groups. This is South Band, of course. All of these names that are being displayed on the PowerPoint Exhibit 21 are on Exhibit 15 in green for Waukesha South Band. Pretty much the whole left half of the formation was endangered by the safety of Darrell Brooks driving up the side of that band. The Extreme Dance Team. It's a little difficult to read, but again, this chart was marked as an exhibit. It's exhibit number 33. If you want it, you can have it in the jury room. The names on this chart will match the names for the Extreme Dance Team on State's Exhibit 15. All of the girls that were struck and injured as they marched with the Extreme Dance Team, plus some people on the back that were handing out candy or serving in support roles as the unit made its way down the street. The Dancing Grannies, State's Exhibit 54, the formation that they marched in, who was located where, and your recollection of how that SUV zigzagged through that group. And you can just see the names and match it up to who was injured and killed versus who wasn't. Now, one of the big things in this case has always been, why did this happen? What was he thinking? Why did he do this?
Yeah, what was he thinking?
Again, those are things I don't necessarily have to prove to you. His intent, I do have to prove, and I submit without any doubt there's overwhelming evidence that this was an intentional act by Darrell Brooks and an act of utter disregard for human life. I say that for these reasons, folks. Number one, first and foremost, just stop driving. That's it. It's really that simple. Not one person had to be hurt that day if he would have just stopped driving.
Excuse me, Attorney Opper, your objection, sir?
Oh, Lord.
You specifically, I'm sorry, can I be heard?
Unfortunately.
Your objection,
I didn't know if I was on mute or not.
You're not.
Please.
You specifically said in your jury instructions that intent cannot be, you can't look into someone's mind, I think is what it says, to find intent. So how could that be characterized as someone knowing for sure intent or not knowing for sure intent?
You're making an argument. You'll have an opportunity to do that later. Your objection's noted. It's overruled. The state may continue.
I apologize.
Oh, wow.
We showed you at the
That
very
won't
beginning.
happen
Remember,
again,
our
I'm sure.
first witness was Sergeant Warner, the man who was the incident commander for the parade. We put up another map. I think it states Exhibit 1. You can have that if you want it. Shows all the positions of all the police officers and the reserve officers, the barricades, the squad cars. How do I know it was intentional? Because even Darrell Brooks told Detective Carpenter, I could tell something was going on downtown. No reasonable person would drive upon this area, see the squads with their red and blues on, see the officers in the street with their bright yellow vests, see all the people milling around, see the floats lining up and the participants getting ready, and not know to drive safely, slowly, and obey officers. The barricades help us prove it was intentional. The police presence help us prove it's intentional. The parade participants help us prove it's intentional. And the parade spectators help us prove it's intentional.
Excuse me, Attorney Opper, your objections, sir?
Oh, God.
Speculation as to what the alleged defendant said he saw. It was
Sir,
never.
Your objections noted, it's overruled. This is closing arguments, not the evidentiary phase.
Mm-hmm. Mr. Attorney.
Go ahead,
So
Attorney
how
Opper.
can speculation be made to what was saw? If
Your
that was never
objections
testified
noted.
to?
It's overruled. Continue, Attorney Opper.
Honking the horn. Quite interesting that Mr. Brooks asked so many witnesses if they heard the horn honking. Some of them said they did at the beginning of the parade. Yeah, I heard a horn honk. Most of them said they didn't. The horn honking cuts both ways, folks. If he's honking his horn, that means he can see something's in front of him.
Uh-huh. Good point.
That means he knows there's an object in the road. You can rely on your common experience in your affairs of everyday life. If you see something in the road and you want to alert the other person to your presence, you will honk. But you do not have the green light to then just keep going if they don't move.
That's right.
He knew they were there. Intent. I've skipped one. I'm sorry. Going back to my street number 15, I failed to include the Catholic community. That's just one of the photographs showing the people that will match up to Exhibit 15 from the Catholic community of Waukesha. There's a lot of photographs identifying the people that were marching with that group. The parade started. This is the starting point, or at least near the beginning, right? This is the area. We showed some videos of the groups passing by in this area. We heard testimony from 4 different police officers standing in 4 different spots near here, telling of their 4 different efforts to stop him. Intentional. Sergeant Wanners back here testified that this red SUV blew by me. I waved both arms over my head. I'm in a police uniform. I have an unmarked squad, but I have my red and blues on. And he blew past me. He gets down here to the corner where Detective Casey is standing. Detective Casey runs out into the street, gets close enough to put his hand on the hood of the car. He keeps going. He comes down, turns onto Main Street, gets in this area of East Avenue to the south and Buckley Street to the north. This is where he encounters Officer Schneider and Officer Buttrin. They each make a separate effort to stop him, and he keeps going. 4 police officers. It's intentional. He had plenty of opportunity to just stop. Anywhere along the way, one of the officers testified to it. I think it was Officer Schneider. This was an accident, and he mistakenly wandered onto the parade route after passing all this. And he mistakenly wandered onto the parade route. At any point, all he had to do was stop. They could have paused the parade. They could have moved the barricades and escorted him out. Didn't. It was intentional. He went on for 4 blocks. 4 blocks. It was intentional. He reached speeds of approximately 30 miles an hour. That's intentional. He plowed through 68 different people. 68.
He almost looks proud of it.
How can you hit 1 and keep going? How can you hit 2 and keep going? How can you hit 3 and keep going? Didn't faze him a bit. He kept going until he got to the end, and there was no more bodies to hit. It's intentional.
What does he have to say now?
Mischaracterization of the evidence.
Noted, overruled. His conduct when he left the parade route, we'll get into this. His flight, his hiding, his panic, his desperation to run. Get the hell out of town as fast as he could before the cops came. That shows his intent. His interview with Detective Carpenter, we spent several hours playing you snippets of that interview. How telling was that? Never once did he say any of these things. Never once did he say, like he told you in his opening statement, it wasn't an accident, it wasn't intentional. Never said that to Detective Carpenter. No, he came up with some convoluted story about, I got a ride out here from a buddy in a tan Kia, and then I left to go meet Erica, and we got into a fight, and then I went back, and the other guy got into a fight, and he was leaving, so I took off on foot. Absolutely nonsensical story. Does not match up with the known evidence in this case.
Overruled.
He never
I didn't
stopped.
even state the objection.
This is closing argument. She may continue.
I'm going to play this slide, which is a snippet from State's Exhibit number 53. Go ahead and play with sound, please. That was just a snippet that I selected because I thought it really captured the environment that so many witnesses tried to explain to you, right? It's a Christmas parade. People are there with their families, their little kids, their grandkids, their neighbors, their friends, strangers, standing next to strangers. That's what's going on Main Street. While that's going on Main Street, this is going on. Remember this? This is the gas station on the corner of Barstow and North Street. While the units are marching down Main Street, entertaining the crowd, Darrell Brooks is driving recklessly. He's enraged, and he's arguing with Erica Patterson. Why is this important? This is important because before he even gets to the parade route, this is how he's driving. He drives the wrong way down North Street and then acts like it's everybody else's fault in the world.
Your objection is noted. It's overruled. You may continue, Attorney Opper.
When he finally pulls into the gas station, he rolls down his window and yells at the driver who's properly stopped at the stoplight that it's somehow that guy's fault that Darrell Brooks is trying to drive the wrong way down North Street. And from there, the rage continues. We get to this point, State's Exhibit number 3. Please play. video's playing. You can see the pushing match between Darrell Brooks, Corey Runkle, Erica Patterson, and Nick Kirby. Watch this. He turns to get in the car, flips up his hood, and goes and gets in the passenger seat. I'm sorry, driver's seat.
How long we gonna mischaracterize testimony?
Oh,
Sir,
shut up.
argument, I've heard nothing improper. Your objection's noted, it's overruled. You may continue, Attorney Opper.
Thank you.
You were a real lawyer.
Nullify.
That's
there
it.
you- Don't you love how he slipped in the nullify thing? That's what he's been working for. Good luck, Darrell.
Drives off onto the parade route. From this moment, right here on Exhibit 15, you're watching it. He's enraged. He's angry. Flips up that hood, and he zooms past Sergeant Warner, past Officer Casey, onto the parade route. Now, there's no doubt, for the first 2 blocks, he does not strike anyone. And as we've discussed, some even said he was driving at a reasonable speed initially. By the time he gets past Officer Buttrin and Officer Schneider in this area here of East Avenue, past East Avenue, and clearly once he gets past Barstow, that's where it starts, right? That's where it starts. Nicole White, our first victim, walking with Remax and a hot air balloon. Knocks her over, keeps going, runs up and over the backs of Waukesha South Band, hits the green children spectating on the sidewalk, keeps going, runs over Kelly Grabo and her daughter Adelia, walking with Burris Logistics, keeps going, plows through the entire Extreme Dance team just before the 5 points, keeps going, hits Deborah Ramirez and her son Isaac spectating on the south side of the street, keeps going, clears the 5 points area, hits Jane Kulik square on, causing her to go up on the hood of the car, and then fall off and drives over her body. He doesn't stop.
Hideous.
He keeps going. Runs through the kids over by the steaming cup. We heard the parents testify about little Brinley and Kelsey and Owen that were standing there outside the steaming cup. They were struck by the red SUV, driven by Darrell Brooks. Keeps going. Plows through the grannies in that zigzag fashion, striking most of them, injuring them, killing them, keeps going, gets down here
Excuse me.
to the end, and goes through the Catholic community. The witness, remember Holly Birch, testified about that mobile gas station incident. She said she was standing down here in this area. She said, I saw 15 to 20 people fly in the air. They look like bowling pins. And when you saw the video, she's absolutely right. It's a terrible description when you think these are human beings, but that's exactly what it looked like. When does the intent exist? Doesn't have to be even for a second. I'm not telling you who set out that morning to cause this carnage. But when he became enraged back here, he didn't give a damn who or what was in his way. He intentionally went on. I'll show you. Motive. I don't know why he did this. Folks, I don't know why. Other than the rage. He's right. You cannot read minds. Neither can I. but the law doesn't require you to. The law gives you a way to reach a conclusion as to what is somebody thinking, and it's right here. Decide it based on his acts, words, and statements, and from all of the facts and circumstances. I've already been through many of them. I want to show you what I mean. Look at this. Was there room for him to get out? This is way back at the beginning. This is Officer Buttrin's squad video. Way back at the beginning. That's Buckley Street here that you're looking at. Look at those barricades. Look at the sparse crowd. And there's Officer Schneider in her yellow fluorescent vest on the left side of the picture, about to run into the street and stop him. Intent. I'm going to play this video for you because, folks, for me, this is where it becomes crystal clear. You watch this video, the first thing you're going to see, if you direct your attention to the left side of the screen, is you're going to see him hit Nicole White. Knock her to the ground and keep going. Now, if that was the end of the story, you may sit here and say, Madam DA, I don't know how you conclude intent from that. Maybe it was an accident. Maybe he didn't mean to do it. But watch what happens in this video after he knocks Nicole White down, and tell me this does not prove intent. Please play. Keep watching the left side of your screen.
Oh, that's horrible sounding.
That's intent, folks. No reasonable person is going to come across a group of teenagers playing band instruments, drive over them, and keep going. That's a still shot of the same thing. That's intent.
I'm sorry to interrupt your objection, sir.
Oh, gosh.
How do you tell the jury what they supposed to think?
Proper argument, your objection is noted, it's overruled. You may
I will
continue.
argue that it's,
Attorney Opper.
I would say that it's improper, and I move
Mr.
for
Brooks, I made
mistrial.
my ruling. I'd
Move
like
for
to review
mistrial.
if you don't
Come on.
Follow the rules.
Exhibit
I move for
1,
mistrial.
Exhibit
Shut up.
152. Clearly intentional conduct. Clearly intentional conduct. States Exhibit 93. We ask the court to take time to have you go look at this car in person because it's remarkably amazing that this damage was caused by human beings. That's intent. This is an excerpt from State's Exhibit 154. Maybe a little hard to see. A lot of that laying in the front part of this photo are shoes. Remember what Dr. Vidritsky said about the shoes, and the feet, the scuff marks on the toes and the ankles? Look at all the shoes laying in the street. This is the area at the end when he ran through the Catholic community. All the shoes laying there because of the velocity. Remember, the medical examiner talked about the velocity. It's not just the speed, it's the velocity. The power that these people were knocked right out of their shoes. That's intent. The flight, the hiding, changing his appearance. He had to go through some effort, right? crawled up in this playhouse, ditched his sweatshirt and his sandal. The other sandal seems pretty reasonable. He dropped it when he was jumping over a fence. Changed his appearance. Please play.
Oh, look at him.
Excuse me.
That's the voice, too. We've all heard.
Intent. What's he running from? What's he running from if he's just a lost guy with no ride back to Milwaukee? What's he running from as there's cops, sirens wailing in the background? Whoops, that was me. So, State's Exhibit number 130. Put that up here quickly. Thank you. I'm not going to go through this whole thing, folks. Suffice it to say, after Officer Skolton tried to stop the threat at that intersection at the top, Wisconsin Avenue, and he blew through the barricades there and drove south on West Avenue over to Prospect Court, cutting through the yards and ditching the vehicle on Maple. Heard all the testimony about the commotion on Maple. The eyewitness testimony from Officer Sailors, off-duty police officer who saw this, saw the defendant, Darrell Brooks. He identified him for you in this court. Get out and run from this car. And how we tracked him through the neighborhood. And again, the desperation, whether he had to ask or use veiled threats like, I won't hurt you, but I need your phone. He was absolutely desperate to get out of there. Until he took refuge in the home of Daniel Ryder. Now remember the interesting thing, folks. None of these witnesses in this area knew anything about what happened at the parade. None of them. None of them were there. None of them were there. So some of them tried to help, some of them didn't. Daniel Ryder did, and it's actually probably a really good thing that he took him in because it stalled, right? It stalled them from keep running, kept them in one place until the cops could close in and get there. State's Exhibit 151, there's the rear plate. State's Exhibit 175, there's Darrell Brooks in his music video with the same car and the same license plate. There's the key to the Ford that was found in Darrell Brooks' pocket. There's no doubt Darrell Brooks is the person responsible for this. Because this man in this picture is the same as this man in this picture wearing this sweatshirt. And again, it's a little hard to see, but you can ask for these exhibits in the jury room if you want. The photograph, you can see this design on the front of the sweatshirt if you look close enough. This is a sweatshirt from the playset that has Darrell Brooks' DNA on it, according to the crime lab. That's him right there. That's Darrell Brooks driving off into the parade. That's Darrell Brooks driving in the parade. That's Darrell Brooks driving in the parade. That is also Darrell Brooks driving in the parade. And so is that. And he kept asking people about the tints on the window. Well, guess what, folks? You don't need to see the tints on the window when the windows are rolled down. And there's clearly one person in that vehicle in every one of these photos. And it's that man, and it's that man, and it's that man. Darrell Edward Brooks Jr., date of birth 2/21/1982, on his identification card issued by the state of Wisconsin. In all capital letters, Darrell Edward Brooks Jr. This was in his pocket when they arrested him. So this entire shenanigans that he's presented to you through his questioning of witnesses about I'm not Darrell Brooks and that's my name and I don't know who that is and I don't consent to being called that name, it's just nothing but a distraction. It's Darrell Brooks. It's the man who drove through the Waukesha Christmas parade and killed people, injured people, endangered the safety of people.
I'm sorry. Your objection, sir?
Oh gosh, no.
Your Honor, with all due respect, I would appreciate the quote unquote language what does she mean by shenanigans and this and that and the third?
Sir, your objection's noted. It's overruled. The state may continue.
Well, can she tone that back? Because if that was me, if I would have said
Mr.
something
Brooks,
like
your
that, it would have been a
objection
problem.
is noted. It's overruled. These are closing arguments. There's nothing
I just-
improper. It's noted.
just
It's
wanted to-
overruled. She may
I
continue.
just wanted to be fair.
You'll have an
Your Honor, that's it.
opportunity to respond, sir. Please let her finish.
So I can rebuttal?
Go ahead, Attorney Opper.
Thank you. I'm going to conclude my comments with this, folks. I'm going to show you the video, a stitched together video of all the carnage caused by Darrell Brooks, and I apologize.
It's together.
This is important that you know
Mm,
what he did.
shut up,
It's
Darrell.
important that you think about the women like Nicole White and Kelly Grabo and her daughter and Jane Kulik, who were just there with friends and co-workers supporting a local business. The teenagers marching in the band, representing, wearing their school colors. It's important. The boys and girls with the Blazers baseball team and their coaches doing nothing more than handing out baseball cards. The young girls in the extreme dance team. Can you imagine how many hours they spent practicing that routine? They drove right through them without a care in the world. The grannies dancing their way down the street, perfect step, every one of them. Catholic community there, as Father Matt said, spreading the light of Christ in the weeks before Christmas. He snuffed it out. It's time for Darrell Brooks to stop running. It's time for him to stop lying. It's time for him to be held accountable for his actions. Darrell Brooks cowardly rammed his way through this parade, violently killing and injuring so many people. I'm going to stop talking, but please, I ask you to add up the evidence. Use the map, 15. You can check off the names. We've covered them all. Walk down that street like we did with you. Return guilty verdicts on all counts. Please. Please.
Screen back up.
No, I need one more. Yes, please. Go ahead.
There is yard equipment in the background. I apologize. I don't know what to do because I live in a neighborhood. Last night I was trying to finish this up and there was someone on the other side of the wall with a drill and that was really loud. So I'm sacrificing the less noisy equipment for the louder one. We'll see how it works. But there's really nothing to hear, but it does kind of ruin the mood. But what I was going to say is it sickens me every time he sits there and watches all these videos of him running over people. I mean, it's almost like he's so proud of his handiwork. I don't know. It just makes me sick to my stomach. Oh, look at Attorney Basie. Oh my gosh, you can hear look at him, and he can just stare at it and not blink an eye. Oh, he blinked for a minute. He still has dead shark eyes, I think. Disgusting, sickening, so sad. Oh. Look at everybody's expression. Oh, please. Oh my God. Please don't show him with the fake praying. I can't stand it. You notice how he did that? Oh, and then all of a sudden it's like, okay, I'm done. And then just goes back and looks at it. Sickening. Sickening. Did you see Judge Darrell? She's trying to... I can't even imagine how it would be to have to see that over and over again. Sickening. Disgusting.
Thank you. Before we continue with Mr. Brooks's closing arguments and
Oh,
take
joy.
a short break, I'll rise for the jury, please.
Muted.
Oh my God.
No.
The jury should know that they can nullify.
You are muted now.
Good move. Look at him. He was not affected by that. He pretend playing and then jumps back up and looks all, well, he doesn't really have bright eyes. And then, does the jury know they can nullify? Oh my gosh. That's why I'm glad she has him where she can do the mute button. Well, I am going to end this because we have to mentally rest up to hear his, I'm sure, ridiculous closing argument. And I'm sure there'll be some fake tears and a tiny tissue to try to dab them. But this is really interesting. I'm looking forward to getting to the sentence, or to the verdict, and then to the sentencing and victim impact statements. That'll still take a lot of videos, really, because this one's pretty long still. But hey, we gotta dig deep on this Darrell thing. So with that, you know what I'm gonna say. I love you all. I thank you so much for liking, commenting, subscribing. Please be kind to one another. Be kind to you. And I'll see you the next time.